Montana-grown Bison Incorporated sells and packages bison meat advertised as Montana-grown. The Attorney General of Montana is suing Montana-grown Bison Incorporated for violating the state's consumer protection law by labeling and advertising the packages of bison meat as Montana-grown because during the winter months the bison migrate across the border into Wyoming to forage. Montana-grown Incorporated claims their advertising is not deceptive and protected by the First Amendment. The main First Amendment issues presented are: one, if Montana Bison Incorporated labels and advertises its bison meat and is deceiving to consumers and unprotected speech under the First Amendment, and two, if it is protected speech, whether the government's regulation serves a substantial governmental interest if it's narrowly tailored and directly advances the governmental interest. The Attorney General of Montana asserts that the company cannot label or advertise the package as bison meat as Montana grown. Montana grown argues their labeling and advertising is protected. The Attorney General has the burden to prove that Montana grown is deceiving and is unprotected by the First Amendment. In Virginia State Board of Pharmacy, the Supreme Court said commercial speech is roughly speech that proposes a commercial transaction. The court further defined commercial speech as anything solely to the economic interest of the speaker or the audience in Central Hudson Gas and Electric versus the Public Service Commission. In Central Hudson, factors to be considered when determining if something is commercial speech is: one, is the speech an advertisement? Two, does the speech reference a product? And three, does the speaker have an economic motivation in speaking it? In the case presented, Montana-grown bison meat refers to a product, and the company has an economic motivation in labeling and packaging its meat in a package labeled Montana grown, ultimately being an incentive for those in Montana buying locally owned. However, if the commercial speech proposes an unlawful act, or if it is deceptive or fraudulent, it is not protected by the First Amendment. In Zotter versus the Office of Disciplinary Counsel of the Supreme Court of Ohio, the Supreme Court held that truthful advertisements are protected by the First Amendment, but the government can punish deception, including which occurs through omission. The court provided an attorney's non-disclosure that the clients were liable for litigation costs was deceptive and an omission. However, the attorney's interest in not providing that information was justifiable and minimal, and thus it was still protected by the First Amendment. An omission regarding the bison foraging in Wyoming for the winter months due to the lack of food in Montana due to the cold and the snow is minimal and justifiable. Thus, it is protected. The second issue is determining whether the government can regulate the commercial speech. To be constitutional, it must be the test set forward in Central Hudson or the reasonable relationship test disclosure requirements from Zonder. In the Central Hudson case, the court struck down a New York regulation ban on promotional advertising by public utilities. Under Central Hudson, a government restriction on advertisement or other commercial speech is permissible only on the showing that 1, the advertisement is misleading, 2, the government interest in regulation is substantial, and 3, the regulation directly advances the interest, and 4, the regulation is not more extensive than necessary. Zonder set forth a second test, a reasonable relation test regarding disclosure requirements reasonably related to the state's interest and preventing deception. The test turns on 3 factors. 1, whether the compelled speech is commercial in nature, whether it is purely factual and not controversial, and the disclosure requirement is supported by a state's interest beyond mere curiosity. The trademark name, advertising, and labeling of the bison meat is an advertisement in itself. It expressly states that this is Montana-grown bison. The attorney might have a substantial interest in requiring disclosure of beneficial consumer information to prevent consumer confusion or deception and be better informed of the product it purchases. However, in United States v. Philip Morris, the Supreme Court decided that controversy means something more than the fact that people might be agitated or simply a disagreement. This case presented solely focuses on consumer curiosity. That is unknown if it would be of any adverse effect to Montana-grown bison, and is not a substantial interest, like human health or the environment. In many cases, including ones involving GMO labeling, it all comes down to whether or not it would be consumer curiosity or whether disclosure of those things could impact health. That is the same as in when we're deciding in pharmaceutical labeling. This case, whether or not these bison are from Wyoming, however, during winter months looking for food, they travel across the state line, is not in controversy, therefore not meeting the test in Zonder or meeting the test in Central Hudson, and ultimately Montana-grown bison would prevail. Some of the public policy issues in this is its far-reaching broad consumer protection laws that would disable the ability for efficiency in a marketplace of ideas, causes overly regulated advertising, minimizing competition and allowing governmental monopolies, and disabling anyone who's not in agreement with the government, therefore creating bad practice and consumer protection. Thank you.